Good afternoon, good morning, good evening, good night, depending on what part of the country you're located at. This is Jasir Jamal from Texas 1031 Exchanges, located down south of the country, of course. So as always, before this video begins, please understand that every single video I have done so far and that I intend on doing, including but not limited to this one, every single thing that I say in these videos is meant for educational and informational purposes only. Please do not construe anything I say in this video as any forms of legal advice or investment advice in any way, shape, or form. Before you make a big investment, whether it be with regards to 1031 exchanges or not, always do your own due diligence before you make any big decisions, and always consult with your CPA, your tax attorney, or your estate attorney before making any kind of big decisions like these, because every investment has its own set of risks. You are never guaranteed to make money. You can lose money sometimes as well, which is why it's important to do your own due diligence and consult with your experts before making any big decisions. Now, let's get into the video. So by far, I'm sure you have heard me say throughout my videos, and I actually did make a video saying this specifically about how long you need to hold your relinquished property or your replacement property in order to do a 1031 exchange. And in all my videos and in that specific video, I've mentioned that 2 years is usually the sweet spot. That is what a lot of CPAs and legal experts recommend, because 1 year is how long you need to hold it for, at least, in order for it to be considered a long-term investment in the eyes of the IRS. But then an extra year, 2 years, is just an added layer of protection. That's why they usually recommend that. Basically, the whole idea behind it is your intent. If the IRS can see that you were intending to hold it for investment purposes, you're good to go. And the longer you hold that property for, the better it is and the less likely the IRS is going to challenge your exchange. So over here today, I've still gotten a lot of questions regarding the 2-year period and where does it say that in the Internal Revenue Code. It does not say that in the Internal Revenue Code, but I did decide to pull out an opinion that the IRS issued back in 2009 regarding this matter. And it still doesn't really say exactly about anything about the 2-year period, but what it does say is the IRS is standing on that holding period. So let me go ahead and read this before. So as you can see, the ruling, the opinion or this letter that came out from the IRS was released on March 27, 2009. And the number that you can find online for it is info 2009-0060. So let's see. This letter went ahead and this opinion went ahead and addressed a variety of different things, but I'm just going to read the part where it addresses the holding period. So let me read it out to you exactly. Accordingly, Section 1031 includes a holding requirement that both the relinquished property and the replacement property must be held either for productive use in a trade or business or for investment. We have gotten that part very clear and we all understand that, right? As the above authorities indicate, an exchange of property will not be eligible for deferral of gain or loss under Section 1031 if the replacement property is determined to be held by the taxpayer for immediate sale, keyword, disposition, or for some other non-qualifying reason. The determination of whether the taxpayer has acquired replacement property for investment purposes is determined by examining the taxpayer's intent and the surrounding facts and circumstances at the time such property is acquired. This determination is necessarily very factual. Now, I'm sure, as I read that, you guys caught some keywords, but the more important thing over here to remember is, let me read that part again, and let me actually write down the keywords for it. As the above authorities indicate, an exchange of property will not be eligible for deferral of gain or loss under Section 1031 if the replacement property is determined to be held by the taxpayer for immediate sale. Let me go ahead and write that out. Where's the marker? Right here. So, immediate sale. Immediate sale. And what else does it say? Immediate sale, disposition, or for some other non-qualifying reason. And there you go. There you go, folks. Let me put this opinion down. So the word immediate sale, disposition, or for some other non-qualifying reason is when your replacement property is not going to be eligible for a 1031 exchange. So let's say, let me address, this keyword is your main person right over here. So you just sold your relinquished property and you just bought a new replacement property and you decided to sell it immediately. Like immediately you decide to sell it. That property is not going to be, if you're doing another 1031 exchange on that property, is not going to be permissible under IRC section 1031, and the IRS is going to challenge it and it's going to be deemed as invalid or disposition or for some other non-qualifying reason. And basically, the IRS has its own set of non-qualifying reasons, but at the end of the day, their most important part about this is your intent. If they can see that you intended to hold this for a long-term investment, then you're good to go. But if they see it as an immediate sale or disposition, they're going to go ahead and discard it because they can see that as a flip. So that's where, as I mentioned before, it still doesn't say in the opinion anything about holding the property for 2 years. That's what legal experts and CPAs recommend. So that's why it's usually best to hold the property for 2 years. And for a long-term investment, 1 year is good. But the only reason people usually say 2 years is because the IRS has challenged 1031 exchanges on replacement properties that were held for a year, which is why people just believe it's safe that you hold it for 2 years in order to prove your intent, which your intent is to show that you held it for investments. And as you report that replacement property on Schedule E of your taxes after you just bought it through a 1031 exchange, you report it there multiple times, the IRS will understand that it was held for investments. And the longer you do it for, the better. Which is why 1 year people are a little edgy about it, but then again, that's something your tax attorney and CPA can make the determination on. But on 2 years, people feel more confident. At the same time, the IRS can see it that way and they will most likely not challenge it. And then of course, if you go above 2 years, they'll be even better. So that's pretty much it, folks. I know this was very vague. I know this was not a ruling from the IRS. It was just an opinion that was released back in 2009. But then again, I mean, this is going to be your keyword right here, immediate sale of the replacement property, meaning you sell it immediately after doing the exchange. That is going to be problematic, and the IRS is most definitely going to challenge your exchange. So it's best just to hold it for a good amount of time. And as I mentioned, the rule of thumb is 2 years. So therefore, I thought I should go ahead and create this video just to bring some more clarification by reading out that opinion that came out from the IRS back in 2009. But aside from that, folks, that's it for me today. I really hope you got some value out of this video. And if you folks have any more questions, please feel free to reach out. But until then, I will see y'all in the next video.